Hi, my name is Volker Kruger. I'm from Velden-Duffey attorneys here in Rustenburg. Court case recently about the validity of a will deals with two wills that were executed by the deceased. One was signed in 2014 with wet ink, properly complying with the formality requirements of the Wills Act. And then there was another document in 2021 where there were electronic signatures attached to the relevant will after the deceased had sent an email to two confidants and asked those two to attach the electronic signature of the deceased and then also sign as witnesses for that relevant will. Question that the court had to decide on is that a valid will? Now, the formality requirements in the Wills Act stipulate that the document that should be executed as a will must be signed by the deceased in front of two witnesses. The deceased must sign each page or initial it and sign at the end or initial it. The initial is basically also a valid signature. And then the witnesses must also sign the document at the end of it in each other's presence. So in this case, obviously, these requirements were not met. So on the face of it, the will did not comply with the formality requirements of the Wills Act. However, there's a section 2, subsection 3 in the Wills Act, which gives the court the power to declare a document a valid will if the court is convinced that the deceased indeed intended that document to be his or her final will and testament, even though the formality requirements were indeed not met, like in this case. So, what did the court find in this case? In this matter, the court was happy that it was proven that the deceased had indeed intended that document to be her valid will and testament, even though it was electronically signed and even though the formality requirements were not met. So the court basically held that in terms of section 2, subsection 3 of the Wills Act, it can cure a formal defect even when the defect is in electronic form, as long as it can be proven once again that that was intended to be the last will and testament. So the other parties referred to the Electronic Communications and Transactions Act 25 of 2002 and argued that because there's an electronic signature and because that act doesn't cater for wills to be signed by way of an electronic signature, they should, or the document should not be declared as a valid will. However, the court didn't agree with this argument. The court said that legislation is not relevant at all. The court doesn't have to rely on that legislation. The court can simply, with reference to the Wills Act, and more specifically section 2, subsection 3, find that the intention of the deceased was to have that as her final will. What is the lesson that we can learn from this? First one, obviously, is to make sure that you get expert advice, like, for example, your attorney, to assist you with the drafting of the will, to make sure that there are no contradictions, so that your intention is clearly reflected in the document, and then also that all the formality requirements are met when the will is executed, so that you don't sit with a court case like in this matter, where even though they were successful with the application at the end of the day to have that declared a valid will, there are obviously a lot of legal costs and delays with regard to the winding up of the deceased estate, which one would always want to avoid. So if the formality requirements were indeed not met and someone has passed away and you are now a family member and you sit with this invalid document, invalid will, what are your options? One option is to go to court, like these parties did in this case. However, importantly, the other option is if all parties cooperate, all beneficiaries of the estate, all family members that are relevant to the deceased estate are happy to cooperate and want to avoid a court case and the costly exercise that goes along with that, they could actually sign an agreement, in my opinion, a so-called redistribution agreement, in which they stipulate that they report the estate as interstate. In other words, there's no valid will, but all of them are happy to give effect to the will because they know that the court application will in any event be successful. So they're happy to give effect to the will and the intention of the deceased, and thereby they can then avoid the costly litigation that goes along with such an application in terms of Section 2, subsection 3 of the Wills Act.